let's see, where was the record? Did I? Oh, wait. Do you guys see where the record is? I just did it so that I wouldn't.
It says
recording. Oh, it says
recorded.
Okay. All right. That's funny because I thought I clicked not to. Okay, so I guess everybody can hear.
Mm-hmm.
All right, we'll give it 1 minute.
Okay.
Do intros.
Val, there's already somebody who said they can hear but not see you. That's intentional, right?
Yeah.
Okay.
I mean, I could put it on. What do you think? I don't know.
I think it's helpful to see you, just you though.
All right. Click to share. I'm trying to click to share the webcam. Webcam. Connecting. Maybe I'm having a problem with the webcam. That's weird.
If you're in remote desktop, it won't work.
No, I'm not. I'm not. And I've used it every time that's just so weird. Well, either it'll connect or not. All right, but it's just 3 o'clock and we still have people coming in, but hello everyone. This is Valerie Bogart at the New York Legal Assistance Group, and welcome to our webinar on the Medicaid cuts that were enacted this last April. And I'm going to introduce Lisa Sutz, who works at DeRote, and to welcome everyone for the East Side Council on the Aging, which is hosting this, or co-hosting this webinar. Lisa?
Yeah. Oh, there you are, Valerie. Thank you.
Okay. Hey, everyone.
So thank you everybody so much for coming, and welcome to the opening of our 2020-2021 slate of programming. What an interesting year it has been and will continue to be. We're going to continue to hold monthly meetings by Zoom. Typically we hold our meetings on the second Thursday of the month, and we're going to continue that way until it's safe to be together in person. So we're going to play it by ear, but until we can meet in person, we'll continue by Zoom. For those of you, if this may be your first meeting, just a quick bit about what ESCADA is. We're the East Side Council on the Aging, and we're a group of professionals that serve older adults, all different kinds of professions, everything from social workers to physical therapists to elder care attorneys, different people who serve older adults in different ways. And the goal of our group is really to get together once a month to share information, to share resources, to network, to better serve our clients. So it's a real great opportunity to be with other people who care about serving older adults and learn more about the resources in the community. So we hope you'll consider joining because we are a membership-based organization. Just a little preview ahead. Next month, we'll be meeting on Thursday, October 8th, and we'll talk about care planning during a pandemic. We'll discuss both care planning for seniors who have remained in their homes and older adults who are in institutional settings. So again, that'll be on Thursday, October 8th. And then just a very brief look ahead. We're excited that we're planning a variety of interesting and diverse events for this year. Subjects of upcoming meetings will include everything from innovations in technology for older adults to the return of our ESCADA book club. So we'll keep you posted via email and on our website. But we want to get started because our time is going to be packed here. Valerie has a lot of information to share. So I'm excited to introduce our presenter this afternoon, a longtime friend of Escada, the expert that we turn to whenever we have questions about Medicaid, Valerie Bogart. Valerie has been the director of the Evelyn Frank Legal Resources Program since June 2002. Originally founded by Self-Help Community Services, the Evelyn Frank program moved to the New York Legal Assistance Group in April 2013, where Valerie continues to serve as their director. EFLRP advocates for access to long-term care and for Medicaid eligibility for healthcare for low-income seniors and people with disabilities through direct legal representation, policy advocacy, legal education, and its website, newyorkhealthaccess.org. We're so grateful that she's here to speak with us about the complex, significant changes set to take effect next month. Although I understand that might be changing, we'll find out. Please join me in welcoming Valerie Bogart.
Okay, thank you, and welcome everyone. Now, we have everyone on mute because there's over 300 people registered today, and to eliminate all the background noise, we're keeping on mute. There is a chat and a question function where you can post questions. There's a lot to cover today, so I don't know that we'll have a Q&A period, but we will be informing you all. We'll be posting more information. Lisa just mentioned our NY Health Access website. If you go on the homepage, there are news articles, and there's always one of the top ones will be about the Medicaid cuts. We did a webinar back in April for WSIACA, Westside Interagency Council, and we will replace that with this one so that you can share it with friends. And we will also be posting information as we get it here. You know, we certainly are not going to tell you everything today because there's so much that we don't know. But what we're focusing on are changes that were enacted in the state budget in April. I'll give you some background on that and how that interacts with the COVID-19 stimulus bills that were enacted by Congress. So there's two basic buckets of changes. It's the new Lookback, and then there are changes in home care eligibility and how eligibility is assessed. Then we're just going to look a little bit at some budget cuts that were enacted earlier, but are now being implemented. So we're starting with a little background. If you're curious on seeing the actual budget law that amends these, that amends the social services law and public health law, there is the link. Knock yourself out. So these changes were recommended by a Medicaid redesign team. This is the second time Governor Cuomo appointed a redesign team to recommend billions of dollars of savings in Medicaid. And keep in mind that he did this before COVID. This panel was appointed in, I think, February, and COVID was around, but most of us didn't know it yet. And so they already intended to cut Medicaid by billions of dollars even before COVID. And when COVID hit in March, you know, big time, that in the view of many advocates gave the governor sort of the leverage he needed to get the legislature to agree to billions of dollars of cuts in Medicaid. So, but these were all not necessitated by COVID, but COVID gave the opportunity to give the green light to these. Now, there's also, this might not be all. The budget law gave the budget director extraordinary powers that normally are not given. That gives the budget director authority to make further cuts in all government funded programs. I mean, not just Medicaid, but education, you know, everything in the remainder of the fiscal year if revenue is down below what was anticipated. Well, we all know revenue is way down. So they haven't announced these new cuts yet because they're playing a game of chicken with the federal government. You know, everyone is waiting for the federal government to act on further stimulus bills. The state is, of course, we're all hoping that the federal government comes through with some money for New York so that further cuts are not needed. But right now, it looks like things are sort of stalled in Washington. Another thing that affects how New York implements these cuts is something called maintenance of effort. So when the Families First Act was enacted, and that's one of the big stimulus bills, part of that wanted to help states that because they knew states would have a lot of extra Medicaid expenses as a result of COVID. So they're giving all states extra federal Medicaid dollars, but with strings. And the strings are something called the maintenance of effort, or MOE requirement. And what that is that states can't cut back at eligibility or the procedures for qualifying for Medicaid during this year while there's a COVID emergency. So they have to keep whatever the rules were on January 1st, 2020, they can't make them stricter. So what that means is that the cuts that were enacted in April can't be eliminated, can't be implemented until the end of the public health emergency, as that is defined by Secretary Azar, the Secretary of HHS. They've now already extended that emergency twice. It now ends October 25th. Whether it's extended October 25th is going to be a very political decision because that's 1 week before, as what did the president say the other day? You know what? A very special day, election day. So there might be pressure not to extend the emergency because that would suggest that COVID isn't under control, which would not be consistent with his message about his effectiveness. So who knows if it will be extended? But right now it means that they can't implement these changes yet. All right. It also means, as far as individuals can't be cut off Medicaid, if they had it since March 18th, or if they get Medicaid now or through October 25th, Medicaid cannot be discontinued or reduced. That means their spend down can't go up, it can't be increased, even if their income increases, even if normally they would have an increase in their spend down, or normally their Medicaid would be cut off because they won the lottery. Right now, they can't be. So, you know, these are all, now we have an article on the website with COVID protections. You can learn more about those by looking there. So because of this maintenance of effort requirement, the Lookback will not start until January. In the law, it says it starts October 1st. It will not. It will not start till January. And the home care changes were supposed to start October 1st. We learned just yesterday in a meeting with some Department of Health administrators that they will not start October 1st. So we can all breathe a huge sigh of relief. He said that they don't think that the regulations will be finalized till Thanksgiving. And then they have to give instructions to HRA and to the MLTC plans and all the county Medicaid programs and all the managed care plans and how to implement them. So it sounded to me like they're looking more like the first of the year. So do we still need to know what's happening? Sure, but it's not as much of a rush that things are going to change so quickly. But some things do start October 1st, which I'll get to. Now, warning, our governor doesn't like this maintenance of effort requirement. And he got a bill passed in the House of Representatives that removes the maintenance of effort requirement just for New York State. That's how powerful he is. He got the whole House to say, nah, New York can cut eligibility any day and still get that $6 billion in funds. That's the HEROES bill. But that's only a bill. It's not a law. Nationally, the health advocacy community, a lot of organizations in the state and around the country are lobbying to keep the maintenance of effort requirements in any Senate bill that's passed and any law that might be enacted around the stimulus. So stay tuned about that. Let's see. Why. Okay, so now we're going to drill down and start looking at the look back. There's been one piece of possible guidance issued that sheds some light about how the state will implement the look back. So if you're sort of wonky and want to look at what they're really issuing, then you have this link on your PowerPoint. And I just want to mention that I did send out the PowerPoint to most registrants, but if you registered late, it's posted as a handout on GoToWebinar. If you look in the little, whatever it's called, there's a place for handouts, and you can download the PowerPoint there. So there were a couple of good things passed in the budget. You know, once again, they proposed to eliminate spousal refusal, and that was rejected. We still have spousal refusal. Once again, they proposed to reduce the amount of assets that a community spouse can keep. So that's a spouse of someone in a nursing home or someone in an MLTC plan or waiver. Now they're allowed to keep, and I'm just being general here, roughly $75,000, sometimes more, if they're not on Medicaid. They wanted to reduce that to $25,000, the minimum that's allowed by federal law, so that New York would be down there with the poorest states in the country with the most bare bones Medicaid programs. That was rejected. So, and then prescriber prevails, which doesn't really apply to Medicare beneficiaries. So we're focusing on the look back. So first, some background for those of you who are not really familiar with what is a look back. A look back is part of the test for financial eligibility for Medicaid. But it doesn't apply to everyone applying for Medicaid. It only applies to people applying for certain long-term care services. So if a look back is required, what it means is that with the Medicaid application, the applicant has to include all their financial records for themselves and their spouse during a period of what's called the look back period. Now in New York, we're going to have two types of look back periods. People seeking nursing home care will have a look back of 5 years, as that's been true for many, many years. The new look back for community-based long-term care will be 2.5 years or 30 months. So when you submit all these documents, it's a big, big package of documents. It's then reviewed by your local Medicaid program. For us in New York City, that's HRA. They're looking for large withdrawals or large checks or large transfers. And if those are not for fair market value, then those could be subject to a transfer penalty. So let's say someone sees that they see you withdrew $5,000 from your bank account. Well, they're going to ask, where did that go? And you say, I don't know. Well, they say, you got to prove that that was not a transfer of assets. Did you take that out and gift it to your daughter? Because if you did, it's subject to a transfer penalty. If you say, no, I bought stuff for my house, show us the receipts. Because if you don't, how do we know that you didn't transfer the assets? So the penalty is, currently it goes up every year. For every $12,844 transferred, the penalty is 1 month that Medicaid will not pay for nursing home care. And the same figure will be used for the look back for home care and other community-based long-term care. You're disqualified for 1 month for every $12,844. This is a regional rate. There's a link to the GIST directive from the state to see what the rate is in other regions of the state. Now, why is this changing? All right. So under federal law, states must do a look back for nursing home care. It is not an option, and it has to be 5 years. But states have the option under federal law of doing a look back for home care and other community-based long-term care services. In all these years, New York has never done it. We've never had a look back on home care or other community-based services. Until now, this is what they enacted in April. Now, the look back can only be on community-based long-term care services. That's a very important phrase. There's no look back, and states may not impose one for community Medicaid, for hospital care, for other acute care, for primary care, for physical therapy, occupational therapy, everything else you can think of that's in these categories. So those applications will remain the same. This will all be fleshed out in guidance. It's just the law has very bare bones changes. So again, this is the guidance that they issued, which raises a lot of questions. I'm going to highlight some of the policy points policy decisions they've made in here. So when does this start? The law said it starts October 1st, but the state has already said it will start for applications for Medicaid coverage of these community-based long-term care services filed after next January 1st. Now, again, there's a chance that might be delayed because of if the federal emergency is delayed, or also if the state needs more time to implement it. This is a lot of procedures to get out to HRA and the other local districts to implement. It's a huge change, a lot of training. So we'll see if they can do it that quickly. Now, it doesn't just apply to new applicants. It applies to someone who is upgrading their coverage with submission of the Supplement A. I think most of you, or if you're not familiar with, then you have to go to our article about Medicaid applications on our website to learn that Supplement A is a supplement to the Medicaid application that's only used when people are seeking long-term care coverage, whether in the community or in a nursing home. So if you file a Medicaid application without Supplement A, it means you are not seeking long-term care coverage. And if after January 1st, you want to upgrade your coverage, you will be subject to the Lookback. So tip for anyone who is now only getting acute and primary care for Medicaid, they might want to submit that Sup-A now, between now and the end of the year. And even if they're not literally seeking long-term care coverage, I can't guarantee this will mean that they won't have to do it after January 1st, but I think there's a good argument that they shouldn't have to, so it can't hurt. And basically, the Supplement A, it doesn't change eligibility. Eligibility is you still have to show you have less than $15,750 in the bank and list all your assets. The difference is, without the Sup-A, you're just attesting that your assets are under the limits. With the Sup-A, you're listing them all and you're documenting that your assets are under the limits. But the limits are the same for Medicaid. So there's lots of things that have to happen in terms of paperwork and approvals that the state needs that I hope will delay this further. So what does it mean to be submitting all financial records for the applicant and the spouse? So this is, I think, a big change for everyone who's used to spousal refusal. Many people, they submit a Medicaid application where the application asks you to list your spouse, so you can never just conceal that you're married. That is potentially fraud. But there's always been the option with spousal refusal to not disclose the spouse's assets or income. Because if they're doing a spousal refusal, they can't be required to use that assets or income for the applicant's support. So we still have spousal refusal, but the Lookback changes this. Now the records have to be submitted of income and assets of the spouse. And why is that? So here's an example of why. Let's say the spouse transferred $50,000 3 months before the application, and she still has $200,000. Now, clearly $200,000 is way over the Medicaid limit. She still has to do a spousal refusal, which she can do. She's still allowed to do that, and that won't count. Now, of course, there's the county or HRA has a claim for support, which they might pursue. Everyone always has to be advised about that. But she has to disclose the transfer 3 months ago, because that transfer, if it was not exempt, would trigger a transfer penalty for the applicant, meaning that there would be a delay until the applicant is eligible for Medicaid to cover community-based long-term care services. So get your arms around that big change, and we have to all be prepared to explain that to clients. Now, in the guidance that the state issued, they have defined which community-based long-term care services the Lookback will apply to. And basically everything. Personal care, which we used to call home attendant in New York City, consumer-directed personal assistance or CDPAP, private duty nursing, the assisted living program, that's a big change, adult day health care, all MLTC types of plans, Medicaid Advantage Plus and PACE. And this one I find very troubling, certified home health care. In comments we're submitting today in response to these proposals, we are objecting that they're including CHA services. CHA services are often needed just temporarily following a hospital stay or a rehab stay, and they're not necessarily long-term, so they should not be included, or they will really delay discharges from hospitals. Can you imagine if you're in the hospital and not everyone qualifies for Medicare for CHA services. They might not be considered homebound under the Medicare rules. They might not be considered to have the daily skilled need required by Medicare. So Medicaid CHA services can be crucial for that visiting nurse or physical therapy. So this, we hope that they will change. And this one, I honestly don't know what it is. Limited Licensed Home Care Service Agency. It seems to be a LICSA home care agency operated by an adult home for their residents. So I'm not really sure how prevalent that is. If anyone knows about that, please shoot me an email because I'm curious of what they're going after there. The state in this guidance has said there will be no look back for these waivers: the nursing home transition waiver, the traumatic brain injury or TBI waiver, the OPWDD waiver, and also not for anyone in mainstream managed care. And mainstream managed care is not very well known to those advocates who work with seniors or people with disabilities, because you're not eligible for managed care, mainstream managed care, if you have Medicare or if you have a spend down. So many of us don't deal with that program very much, but millions and millions of New Yorkers are in those plans. And even including elderly people, if they don't have Medicare, often because of immigration reasons. So, but they're generally very poor, and the look back is probably not going to be a problem for them. Also, people with acute, well, also not for primary care. So the look back is going to be phased in, and as it was back in 2006 when they implemented the Deficit Reduction Act. So the idea here is that assets transferred after October 1st of this year, which is in 2 weeks, will be subject to a penalty. And any assets transferred before that date will not be. So that means the look back will never look back before October 1st of this year. So when they implement the look back in January, the look back will only be 3 months, back to October 1st. A year later, it will be 15 months, back to October 1st. Then it will be 27 months a year later, until finally in April 1st, 2023, it's a full 30 months. Now, what does that mean? It means people have 2 weeks to make any transfers of assets that will not affect their eligibility for home care or long-term care. So if you happen to be counseling anyone in the next 2 weeks, or if you counseled someone in the last month, you might want to go back through your closed advice cases and just give those people a ring and say, we talked about how there's no penalty on transferring assets for home care. Well, that changed, and assets transferred after October 1st will have a penalty. And since this was passed in April, I don't know if there would be a malpractice claim there if we didn't advise someone on this, but I'm sort of thinking out loud here that I think we should all do that. So there's some, they made it a little more complicated, but for good, well-intentioned, all right? Not every new Medicaid applicant will, even looking for long-term care services, must do the look back. Again, this is in this proposal to amend the waiver. So if the person is so poor that they are eligible for Medicaid with no spend down, it means their income is under the $875 with the applicable deductions for health insurance premium, the $20, or if they're working, well, let's see, I'm not sure if working, I'm not a, you know, some of this is by implication, all right? What this implies is that if they're that low income, they will not have to submit the look back documents. Also, if they are Magi eligible, they will not have to submit the look back. So everyone who, you know, mostly represents elderly people or people with disabilities, we usually don't screen for Magi, but I think everyone will need to do that. And maybe we'll post some helpful tips for screening for Magi. But I mean, the only way somebody with Medicare over 65 would be Magi eligible is if they're a caretaker relative for a child, a minor age child, or grandchild, or niece or nephew. So when we're talking minor, under 18, or under 19 if they're in school. So that it doesn't happen that often, but it can happen. All right, so that's something to think about. So what they said specifically is that it will be required for the medically needy category, which is the fancy federal term for the spend down program. Anyone who would have a spend down, and my view is that that includes people who would have a spend down if they weren't using a pooled trust. They are still considered medically needy because they're not poor enough to qualify just based on their income. They're also saying the look back would be required for the Medicaid buy-in for working people with disabilities, which in our comments we're also opposing, because it's, you know, they have all these work incentives for people under 65 and disabled. So why put in a disincentive? You're trying to encourage people who have disabilities to work. So having the look back just is contrary to that goal. So I was glad to see that they're not going to require the poorest recipients to submit all this documentation. But when you think about it, how are they going to implement this? So how would a client know whether they have to submit the look back with their application? They have to know whether they're categorically needy or medically needy. Nobody knows that. Many of us don't know that, right? I mean, we pride ourselves at NILAG about knowing that, but we are wonks. We know budgeting. Most people aren't. So, and how HRA and all the local districts also have to know how to, differentiate who does have to do the look back and who doesn't. So I'm a little afraid that they might drop this and just require it for everybody, because it will be too hard to differentiate these different groups. But we will see. We will see. These are the things we don't know yet. We just know about this because they put this in this waiver proposal, and it raises these questions that I'm sharing. The same thing is true about them saying that people who are seeking to enroll in these special waivers, like the nursing home transition waiver, the TBI waiver, the OPWDD waiver, that they don't have to do the look back. But when you think about it, they can only apply for those waivers after they have Medicaid. So it still begs the question, when they apply for Medicaid, how will they show that they intend to apply for one of those waivers? And will that be enough to say that they want to apply for one of those waivers? I mean, I think that will end up being, if they stay with this, those of you, who elder law attorneys who counsel people who, and even, us in legal services, and people who do have some money over the limit and are transferring it, perhaps the nursing home transition waiver will become much more popular because there'll be no look back for it. But don't know yet how they're going to, operationalize this. So more questions are raised on who will not have to do the look back. So who's grandfathered in? So the strictest view would be that anyone who's actually receiving home care in an MLTC plan or through CASA or your DSS or in assisted living program don't have to do the look back. Okay, we know that, like those people. But then there's a big gray area. Like, what about the person who applied for Medicaid this year, 2020, and it was even approved with Sub A, but they're not yet receiving services? Now, we know there's many reasons why that could be. They're waiting for the conflict-free assessment, where it was done, but they haven't gotten a plan to come and assess them yet. Or a plan has come to assess them, and the enrollment is set. Let's say it's now December, but it was too late to enroll for January 1st, so it's rolled over for February 1st. So in our comments, we're urging the most liberal view that anybody who applied with the Supplement A before the 1st of next year should be grandfathered in. And there's still time to submit comments. So if you want to echo some of these, please do. We'll post our comments in that news article, and you can feel free to echo them. The other glitch that we're afraid about, how about people, let's say they're in a plan, they're getting care in 2021, and then what happens? Medicaid gets cut off. The COVID-19 special emergency ends, they're back to doing renewals and cutting people off after glitches happen in renewals, which we deal with all the time, and the person has to reapply and their home care gets interrupted and they're reapplying in 2021. Now, will they be grandfathered in? This is another gray area, and we're asking for them to be grandfathered in. They shouldn't. They're only reapplying because of a bureaucratic problem. Oh, I'm sorry about the honking. I hope it doesn't interfere. So the transfer penalty, how long is a penalty? It's calculated exactly the same as it is for the nursing home. You take the total amount transferred. In this example, let's say it's $39,000. You divide it by that regional rate, which in New York City, I'm going to round to 13,000. and I'm rounding this to penalty period of 3 months. Penalty, in which Medicaid will not pay for home care or the assisted living program. So it works exactly the same as in a nursing home. The exceptions to the transfer penalty, they are saying, are also the same. Excuse me, I'm just going to close the window. For assets other than the home, just very briefly, transfers to a spouse, to a child who is certified blind or disabled. If the person is under 65, they can transfer it to a supplemental needs trust for themselves or to someone else who is disabled and under 65. If the asset is exempt, transferring it doesn't have a penalty. So those, they have said, will be the same. And there are a number of other ones. I can't totally go through all of these, but there is on our website, if you look under Medicaid, the nursing home category, there's an article about transfers of assets that goes into more detail about these exceptions because they will be the same. But I want to talk about some exceptions that should be different. So there's one exception to the penalty where, let's say your client transferred assets, they gave them to their daughter and as a gift, and she spent the money on her kid's college and it's gone and there's nothing to do about it. It's just gone, and that gift doesn't qualify. Sometimes those things could qualify for another exception, but let's say it doesn't. So if you denied her Medicaid for a penalty period, there's an exception that if it would cause her an undue hardship, if it would deprive her of medical care, endangering her health or life, or depriving her of food, clothing, or shelter, and she's unable to have the resources returned despite her best efforts. Now, the way the state has defined undue hardship would not work in the community setting. They define it as that after paying medical expenses, the income and resources must be below the Medicaid levels. So if the person has a spend down, they're not eligible for undue hardship, period. They are deemed to have enough money to pay for their care. And we know that that doesn't make any sense. Now, in the nursing home context, that arguably made sense because if someone's in a nursing home, all of their needs are being met in theory by the nursing home, right? They're being fed, their light bill is being paid, they don't have to pay taxes, all their medical care and shelter is being taken care of. So all of their income can go theoretically to the cost of their care. And that's a payment of medical expenses. So they might qualify for undue hardship. But in the community, this wouldn't make any sense because the client has to maintain her home. So in our comments, we're asking the state that they have to change this definition. It just doesn't make any sense in the community. And the other thing to be, once this is implemented, to be aware of, you can't submit the look back, have your application be denied because they're denying an exception, and then ask for undue hardship. You have to anticipate that you might need this hardship exception and ask for it with the application that's in these requirements. Now, transfer of the home is another thing that should be different in the community than in a nursing home. So in a nursing home, there are special rules around the home, which we're not going to go into in depth. But if the home is transferred to certain relatives, it's considered an exempt transfer, like the transfer to their spouse or to a disabled child or a caregiver child who lived with the client for 2 years before they went into the nursing home. So, one possibility is that state will say, okay, those exceptions apply. But if you transfer the home to anyone else, there's a transfer penalty. And that's how it works in a nursing home. And they may say that that's how it works in the community. We don't think that's how it should work in the community. And the simple answer, reasoning for that is that the house is exempt when you're living there. And it's a little complicated how the rules define this, but that's like the simple principle here. And the principle is that when you transfer an exempt asset, it doesn't have a penalty. Like, let's say I only have $5,000 in the bank, well under the resource limit. If I transfer that $5,000, there can't be a penalty on that because I'm allowed to keep it. So how could I be penalized if I give it away? So the same thing with the house. You're allowed to live in it. You're allowed to have it under your name. How can you be penalized if you give it away? So this is another thing that we're waiting to see what the state will do. And our comments that we're submitting to the state, we're making this argument. And again, we'll post this on our website. Will this all cause delays? Yes. Very afraid about big delays with all of this. And even for those applicants who don't have to submit the look back, I think the state was well intentioned there to say we don't want to delay things for them, so it would be easier for them to put together their application. But the Medicaid workers are going to be busy on going through all those look backs, so it's still going to cause delays, even for those people who are the poorest applicants. And they have these federal deadlines. A Medicaid application has to be decided within 45 days. Or if it involves a determination of disability, 90 days. And those would be any application submitted with a pooled trust for someone over 65, for which you have to ask for a determination of disability. So they do legally have 90 days for that. But this could cause, take much longer. Immediate need applications, they're supposed to decide in only 12 days. So how is that going to work? So in our comments, NILAC is asking for the state to allow an applicant to attest that no transfers were made in the 30 months or whatever it is as it's being phased in. Big question people are asking is, can we still use pooled trusts once this look back goes through? So this is still, we don't have any definite answer on this, but let me just tell you why is this even an issue? It's an issue because under the federal rules, you have a penalty if you transfer assets or if you transfer income. The transfer of income is considered a transfer. And actually, that's a good thing because that's why we could even use pooled trusts. The protection for putting income into pooled trusts comes from this rule that treats transfers of income like transfers of assets. And if you have a disability and you transferred it into a supplemental needs trust, then that income is exempt. But now that we have a transfer penalty, it raises a question of, is that a transfer that can trigger a penalty if you're over 65? If you're under 65, it shouldn't, because one of the exemptions we looked at before is that someone under 65 can transfer assets or income into a supplemental needs trust, and that is exempt. So we think, we're, as a member of the State Bar Association and in NILAG, we have found authority in the state directive and in the CMS Medicaid manual that says as long as the money put in the trust is used to benefit the individual and the trust purchases items and services at fair market value, then income and resources placed in the trust should be exempt. So we think there's authority on that. The State Bar Association is working hard on trying to convince the state of that, and we're hopeful that the state will agree on this. But I can't give anything definitive right now. Certainly, people should continue to use pool trusts, continue to open them. We have to be hopeful, because obviously we know many of our clients could not live in the community if they were not using a pool trust to be able to use their income to pay their expenses. Now, here's another big issue with bringing this look back into the community. So when does a penalty period begin? So you apply and you have a look back, and they say that you have a penalty. So when does the clock start ticking away so that penalty can run out and you're eligible for Medicaid? Well, the law says the penalty begins the first day you're receiving services for which Medicaid would pay, but for the transfer penalty. A lot of legalese there, but the key there is receiving services. So in a nursing home, that definition works fine, because you can only apply for nursing home Medicaid when you're in a nursing home, receiving nursing home services. So in a nursing home, that penalty can begin running the day you are admitted, if you're eligible for Medicaid on that day, except for the penalty. So in a nursing home, even if the application takes forever to be approved by HRA or your local DSS, once it's approved, it can be approved retroactively back to the nursing home admission. So we have a little primitive graphic here. Let's say Susan transferred $40,000 on October 1st. I guess that should be 2020. Let's say 2020. And well, I guess actually, yeah, 2020. And let's say it's within the look back period, just for illustration. She goes in a nursing home in January, files a Medicaid application 3 months later because it can be retroactive back to January 1st. It gets approved just on time, 45 days later. They assess a 3-month penalty, which runs back to January 1st. So the penalty has by the time they've approved the application, she's already now eligible for Medicaid coverage. She was eligible as of April 1st. So yes, there are 3 months unpaid, and the nursing home will certainly want her to pay that. The family and her need to work that out with the nursing home, but at least she's getting the care she needs, and the penalty is only for those 3 months, and Medicaid covers the rest of her stay. So in the community, it can't work that way because you can't be receiving home care that Medicaid would cover until Medicaid is approved. You can't enroll in an MLTC and private pay. You can't private pay for CDPAP. And you can't get it approved for any of those services until you've applied for Medicaid, it's been accepted, and you've gone through all of the functional eligibility hurdles, like the conflict-free assessment, or if HRA or your local Medicaid program is approving you for services. So we think the solution is that what the state has to do is there is guidance from CMS that says in home care programs, they can start the penalty when the person would otherwise be receiving home care. So in other words, when they're functionally eligible for home care and not actually receiving it. So to do that, we'll have to add to the application process something like a physician statement that would show functional eligibility. And that way it could work sort of like in a nursing home. If they don't do that, the whole transfer policy will push people into nursing homes because it will be much more favorable for anyone who's going to have a penalty to be in a nursing home. And that, we think, could violate the Olmstead decision and the Americans with Disabilities Act. I think I'm going to skip this graphic, but you can look at it on your own. All right. We don't have a lot of time for the home care changes, so we're going to run through these. Again, the state has issued one document to shed some light on how they plan to implement these. Here's the link to the PDF, their proposed regulations. Comments are due a week from Friday, September 14th. We are submitting comments and we will post them on the NY Health Access website. So there's sort of three sets of these changes. There's a new minimum number of ADLs that will be required to be eligible for home care and MLTC enrollment. There's a whole new assessment procedure that's going to apply both in the local districts like HRA, CASAs, and in MLTC plans and in mainstream plans, with a new expanded role for Maximus, New York Medicaid Choice. And they propose regulations to make it easier for plans to reduce hours. Now, the news as of yesterday, all of these were supposed to start April 1st, or at least the first two. I misspoke, October 1st. As of yesterday, they have admitted that there's no way these are starting October 1st. They said yesterday the earliest they'd have regulations finalized would be like Thanksgiving. But that's just finalizing regulations. They still have to implement. So I don't see how it could possibly done before January 1st. So that should give us all relief, and we'll see more of this fleshed out. So the first change. Now there is no minimum requirement that you have a need for assistance with any particular number of ADLs to qualify for home care. An ADL is an activity of daily living, like walking, toileting, eating. We'll look at a list in a minute. There's no minimum. In fact, you can get home care even if you don't need any ADL assistance, because we have something called the housekeeping program, where if you need help with IADLs, which are instrumental ADLs, but not ADLs, you can still get up to 8 hours a week from your local Medicaid agency. What's changing is a new minimum, and it looks like they are eliminating the standalone housekeeping program. There will no longer have this service available, although we were told yesterday that people getting housekeeping now will be grandfathered in. So if you have clients who might need housekeeping between now and December, file those applications because they'll be grandfathered in January 1st. But if they don't have it by January 1st, I don't know that it will be available anymore. So now most applicants for personal care and CDPAP must need assistance with 3 ADLs. And that assistance must be assistance with physical maneuvering, not just prompting and cueing, actual physical maneuvering, unless they have a dementia or Alzheimer's diagnosis, in which case they can qualify if they need supervision with 2 ADLs. Now, this, as I said, this is supposed to start October 1st. So again, there's a grandfather clause. People who are already receiving any of these services as of whenever they implement it will be grandfathered in. Again, it's a gray area. Is it enough that you applied for the services? Do you actually have to be receiving it? We don't know. But we know people who are actually receiving it will be protected and will not have to prove these, that they meet these requirements even on renewal. We understand that this is, these apply, they'll be grandfathered in as long as they get services. So which ADLs? In their proposed regulations, they've defined 7 ADLs, which are listed. I'm not going to read them, but I'll point out what we noticed was missing here: administration of medications and transfer. They have transfer, but they define it as only transferring on and off the toilet and using the toilet. That's good. It is an ADL, but how about transferring to a bed or from a bed or to a chair or from a chair? If someone has a catheter, they're not using the toilet, but they still might need the ADL of transfer. So our comments say that that has to be included. And also, they shouldn't just use the word toilet because there's many types of care involving elimination, including incontinence care, commodes, things like that. So we think that should be broader. The other thing is that they are not counting at all assistance needed with IADLs, instrumental activities of daily living, which we commonly call it housekeeping, cleaning, shopping, cooking. Now we all know that someone might still be able to dress and bathe themselves, but not schlep heavy bags of laundry down to the basement laundry machines or schlep groceries home. So, and if they do try to do that, they are at risk of falling, and now they will come to need more care. So it's a very preventive service to provide that assistance. So we think they should count that also. Now, just to give you a sense on the UAS, the Uniform Assessment System, it has instructions, which we have on file. And for the ADLs, they have a range of 7 types of assistance, from someone who's fully independent to total independence. So this new standard of limited assistance falls about in the middle, and it's defined as guided maneuvering of limbs, physical guidance without taking weight. So look, we're glad they didn't require extensive assistance, weight-bearing support. So, one question is does one of our fragile clients who can ambulate with a walker but needs contact guarding, would that be counted as physical guidance without taking weight? I don't know. But this is where all of us who, advocate, who will be now present, when you're coaching someone to get through the conflict-free assessment, this is going to be very important. You are going to have to be convincing that nurse that your client needs limited assistance with 3 ADLs, unless she has dementia, and then it's okay to need supervision, defined as oversight and cueing, with 2 ADLs. So this is it. I mean, these are the new criteria. Maybe I'm, crying wolf. Maybe 99% of our clients will meet these criteria. Certainly our clients who have severe disabilities, it's a no-brainer. They need all 7 ADLs. But I'm thinking of the people who are, just the more frail and still somewhat independent and can't safely do things without that contact guarding. And I'm worried about them not meeting the 3 ADL criteria. Now, for people who need supervision, they're only saying you qualify if you need supervision if you have dementia or Alzheimer's. And this is in the law. This is in the budget law. Well, how about a traumatic brain injury? How about developmental disability? How about visual impairments? And the state assembly health chair, Richard Gottfried, and the Senate health chair, Gustavo Rivera, proposed a bill that would say, wait a minute, you've got to include all these other impairments. And that did pass in the Senate, but it hasn't been up for a vote yet in the Assembly, so it's not law. So right now we just are stuck with these 2. So, this is a problem because there's a lot of people, especially not everybody with the TBI is in the TBI waiver. Not everybody with a developmental disability is in the OPWDD waiver. And even if they are, they might still need personal care. So this is a big, big gap. And we think that it's illegal discrimination based on diagnosis. They're also, and this is something, if you've been to any of our trainings in the last 10 years, we've been warning you about this. Don't ever say that a client needs just safety monitoring or supervision. You always have to think of which ADL do they need safety monitoring with. They need cueing and prompting for safe ambulation. And I'm not telling you to lie, it's just thinking about things in a different way. The fact is that all safety assistance is connected to an ADL. You just have to make that connection and make sure that the need that you're describing describes it that way. Now, one of the changes in the regulation will water this down, and we're afraid will allow more denial of services for people who do need supervision and cognitive prompting. So it's even more important to make sure you watch your vocabulary when you're helping doctors or families articulate what kind of help the client needs help with. All right, we're turning to the new assessment system. So here's what's changed. There's still a UAS, but right now let's put aside MLTC enrollment. Let's just assume that you're in the plan now. You're in the plan. It used to be that the plan nurse would do the UAS. That would then be the basis of your plan of care. Now it's going to be New York Medicaid choice. If it happens that you're a new MLTC enrollee, they will use the conflict-free assessment and not have that done twice. That's about the only efficiency that I can see from all of these changes. Now, so it's the new, they call this the independent assessment. So this isn't just an enrollment. This is every year. You have, now it's going to be an annual reassessment, not every 6 months. That UAS will be done by New York Medicaid choice, not the MLTC plan or mainstream plan or local district. Then it's referred to a physician from or under contract with New York Medicaid choice. And it's only after both of those assessments are done does HRA or your local district or the plan authorize services decide on a plan of care. Now, if that plan of care is for 24-hour care, then it's referred to another assessment, this panel of medical professionals that assesses high-need people to determine if the proposed plan of care is reasonable and appropriate to maintain health and safety. So in their rulemaking, they say none of this will cost any extra money. But I'm thinking about how much more are they paying Maximus to do all of these assessments. This is the state's flow chart of how this will all happen, okay? Now, we asked them, well, how about a new enrollee, someone who's calls Maximus, New York Medicaid choice for the conflict-free assessment, which is here, this yellow block. CHA, they call the UAS the CHA, Community Health Assessment. And we're worried that you won't be able to enroll in a plan until after this step, which is the physician assessment. Yesterday, we had a call with the state. We made this point, and we made the point that this will cause big delays in enrolling in MLTC plans. And they said they will consider allowing you to enroll right here in this slot based on what we're already familiar with, the conflict-free assessment, and have this physician's assessment done later. I would say preferably while you're waiting to get into the MLTC plan. There's always a waiting period because of the first of the month enrollment. So we're going to have to see how that goes. So the MCO, managed care plan, develops a plan of care. If they say, well, this says 12 or more hours, but I thought it was only more than 12 hours, gets referred for a high panel, this high need panel. Now we have a hard stop at 4:45, so I'm going to see, just going to point out a few things here, might leave out some things. One of the things in the regulations that was really alarming was that this nurse does the assessment from New York Medicaid choice, and it allows the plan or the local Medicaid agency to review that and direct the nurse to correct factual inconsistencies in the assessment. So how is that independent? This whole thing was enacted to take away from the plan and from the local district that might have some self-interest in evaluating need. So, you know, that's very worrisome, that they sort of giving them like almost a veto power. And of course, we're concerned that they assess whether informal caregivers are really voluntary, and it's what the consumer wants and not just, you know, required. And of course, are they adequately assessing nighttime needs. Now, this physician's exam, we have a lot of questions about. We don't know where this exam is going to be. Is the client going to have to travel, or is it going to be in their home? They're not even required to consult with the treating physician. There's no role for the consumer's doctor in this entire process. It doesn't say that the consumers are right for their family member or advocate to be present. So there's quite a few concerns there. The high need review, let's say the plan sends, let's say they send to this high need review their plan, which is to give live-in services. And the consumer has requested split shift, just for example. There's no requirement that these high need reviewer be informed of what the consumer wanted. So we think that in that case, the plan's going to say, this high need review team is going to say, well, no, this consumer wouldn't be safe with live-in. But they're not allowed to recommend a specific number of hours or an alternate plan of care. That's what their proposed regulations say, which is sort of insane. Like, what's the point of this review if they can't say this plan wouldn't be safe, but this other plan would be? So these are the kinds of things we've commented about. Another concern is, if in order to get 24-hour care, you must have a stamp of approval from this high needs review panel. What if your plan said, well, we think you need 8 hours a day? So they don't refer it to the high need review panel. Well, then the consumer does their plan appeal, goes to a hearing. The judge says, well, wait, under the regulations, you need to have a high need review that says that you would be safe at home with 24-hour care. But that wasn't done because the plan didn't think you needed 24-hour care. So we think the plan should be required to send it to this review panel, even if they don't think you need 24-hour care, if that's what the consumer requested. Now, the concept of Olmstead and giving an opportunity for people to live in the most integrated setting hangs over all of this. If they are talking about who is safe in the community, the Americans with Disabilities Act has regulations that say, look, when you look at safety, you have to be looking at actual risks, not just speculation or stereotypes about people with disabilities, which is what a lot of safety concerns are. I mean, if you look at many of our clients, how they live, someone who doesn't really understand their life and the choices they've made might think that they could only be safe in a nursing home. But it's based more on stereotypes about them and not actual risks. So we think that they have not done the right job of incorporating a lot of requirements about assessing these risks. All of these assessments are going to cause huge delays. And when you look at federal regulations, they require plans to turn around requests. You request an increase in services, the standard request has to be decided in 14 calendar days that they can extend for up to another days. But you can request for it to be expedited, and here's the standard, based on that delay would seriously jeopardize life or health, or ability to attain, regain maximum function. On most requests for an increase in home care, you meet that standard. That's why you're asking for it. So if you meet that standard, they only have 3 business days to turn that around. How are they going to do all of these assessments in 3 business days? I mean, and that the state has set it up so that it can't be done. Now, let's just look at reductions for a sad moment. You know, thanks to litigation that was done by some, you know, wonderful attorneys in New York City over literally 25 years, starting with this case, Mayer v. Wing, from Cardozo Law School, JASA Legal Services for the Elderly, and NILAG. There is precedent that we are now enjoying, which says that home care that was authorized in a certain amount can only be reduced if HRA or a plan or the local district send notice that specifies that they can identify a specific medical improvement or change in social circumstances that reduces the need for the same amount of services as you've been getting, or a specific mistake that occurred in the previous assessment. And I strongly urge you to look at the DOH policy 1606, which really fleshes this out. It gives great examples of all of these, so you know that they're very, very limited. I don't think the plans read them, because to read their notices, they say mistakes have been made on every previous assessment, but they really can't, because this guidance says there's only very few types of mistakes that are allowed. So they've added, in these, they're proposing to add new grounds for reductions. And the first new ground would be that the client's needs can be met either without services altogether or with a reduced amount of services by fully utilizing available informal supports or other supports and services. Now, we already have, if you go back, what's already allowed is a change in social circumstances. That's already been allowed for 25 years since Mayer v. Wing. So let's say your daughter just retired, wants to move in with you and take care of you, and is happy to provide a lot of the care. She just wants some time, 2 days a week, to take care of her personal needs. The rest of the time, she's more than happy, and you're delighted. It's your favorite daughter, you're delighted. You're both happy with it. Could that be a ground to reduce services? Sure, absolutely. But the beauty of how the original reasons are written is that it's the burden on the plan or the local district to prove that the change occurred. The way that they describe it here, they can just say it's Groundhog Day, and we think today your daughter can take care of you 5 days a week. We don't really care what was found earlier, and we don't have to prove why we're making this change. So this would be really open it up for plans just to say, we think your family can help out a lot more than they are, and not prove it. So that would be terrible. The other ground is really disturbing. It says that, well, our assessment of the client's needs says that your last plan, or when you got services through immediate need from HRA, they authorize more services than are medically necessary. So we're going to cut your services. And they're allowed to do this following any required continuity of care period. So what's a continuity of care period? So it's a period following certain changes. When you have immediate needs services, after 120 days, you're required to enroll in MLTC. So the continuity of care period is 90 days after that enrollment. When you were in a mainstream plan and then you got Medicare and you're transitioned to MLTC, you have a 90-day continuity period after that transition. If your old plan closed, like ICS closed and GuildNet closed, and you're transitioned to a new plan, there's a 120-day continuity period after the transition. Now, we've always argued that when that continuity of care period ends, a plan could only reduce services for the reasons that were on that earlier slide. Your medical condition improved, your social circumstances changed. This would allow them to change it just because, well, they gave you more than we think you need, with no requirement to justify that. So it would completely wipe out, and this is particularly disheartening because when DOH issued the 1702 policy on plan closings, we asked them, advocates all over the state asked them, can you make it more detailed and make it clear that after the continuity of care period, the plan has to issue notice if it wants to reduce services for these allowed reasons. And we were told, it's not necessary, it's so obvious. We don't have to include it. That's what they said. I wish it was on tape. And now they're completely backpedaling on that, completely changing that. Another ground would allow them to reduce services if they can demonstrate that telehealth services or assisted devices would reduce the amount of services that are medically necessary. All right, maybe telehealth could somehow be used to remind someone to take their medication at night. You know, maybe a nurse calling the client. Okay, but which activities of daily living can telehealth really help with, or laundry or meal preparation? So that seems sort of ridiculous. Some other changes that we don't really know yet how they're going to be implemented, but DOH has it in for the CDPAP program. The program has grown a lot, and it's really relied on a huge amount of state where there's such an aid shortage. So people really rely on the fact that they can hire a family member, certain family members, to be their personal assistants in CDPAP. And in COVID, this program has been a lifesaver because many people don't want aides coming in and out of their home, exposing them to the virus, but they're willing to have a family member who they, in their pod, right? So this program has been a huge lifesaver. So under the state budget law, new applicants will no longer be notified of the availability of this program. And it limits the opportunity to apply for CDPAP to no less than annually. Now, I don't know exactly what that means, but it might be that you only have once a year opportunity to enroll and tell your plan, I'd like to shift to CDPAP. But it's something to keep in mind. In the proposal, they want the designated representative for someone not self-directing. Let's say your mom has dementia and you're the one who's managing her care. You have to be physically present for all of those assessments we listed before. Now that sounds like a way of playing gotcha, because what if you're working full-time and you just can't be physically present, but you're happy to be on the phone talking to the nurse? You know, if you have to be physically present, can they cut your mother off CDPAP if you're not? They're going to be rolling out a new task-based assessment tool, not a UAS, but some tool to count up how many hours you need. That's coming next April. So, you know, fast and furious, these changes. There's been litigation around the country about some of these tools that have, you know, I can just imagine, you know, it making it impossible to qualify for split shift care because the logarithm in the tool will make it, nobody would, maybe 3 people will qualify. So, you know, that'll be another battle. I think we'll skip this because we only, just a few things of things, old cuts that are now being implemented. They plan to start the lock-in December 1st. So that means people newly enrolling or transferring to a plan after December 1st will be allowed to switch plans within the first 90 days. But in the last 9 months of that 12-month period, they will be allowed to change plans only for good cause. And this does not apply to people changing to or from a PACE plan or a Medicaid Advantage Plus plan. Information will be going out to consumers. Good cause is not officially detailed anywhere, but they have indicated that it will be, of course, if you're moving to a different service area, if the plan fails to furnish services, you didn't really consent to enroll in this plan in the first place, so there was a mistake that happened there or some pressure. And I believe that it will be good cause if your aide is no longer working with the current plan, you could move to a new plan. Now, we've always cautioned people about this anyway. We don't recommend people changing plans because there are no continuity of care rights when you voluntarily transfer plans. So if you have 24-hour care and you don't like your plan and you think another plan will be better, that other plan does not have to give you 24-hour care. They can say, sure, come to us and we'll give you 8 hours a day of care. And you have a right to appeal it, but not as a reduction in hours because it's voluntary. So we always caution people. We got some data on how many people change plans. 35,000 people change plans in 1 year. Actually, in another 4,500 change 2 to 6 times. So I guess they see this as a problem. I don't know why it's such a problem, but the plans have complained about it. So they're doing lock-in. Another thing that they've just implemented is that if you are in an MLTC plan and you go into a nursing home for more than 3 months, once you're determined eligible for institutional Medicaid and you're in the nursing home for 3 or more months, you will be disenrolled. Now you're going to get notice that will say, hey, did you expect to go home? You can still request to stay in your plan. You can appeal this discharge because you say you have an active discharge plan, but they just disenrolled almost 16,000 people August 1st who were in this situation. And, you know, advocates, NILAC, Legal Aid, Empire Justice Center, you can look at our letters to the governor, really demanding that they don't do this in the middle of a pandemic when letters were sent to people in nursing homes who who could not be visited by their loved ones, who could help them understand the letter and respond and request a hearing. And of course, this fell even more disproportionately on people of color, who make up more people in nursing homes on Medicaid, and more people who have died of COVID. So state did not respond to our letters. And though this is going to be going on, this is something that all of us have to be watching for as people go temporarily into a nursing home for rehab, to make sure that there isn't a slippery slope to that going for Medicaid. Okay, we have 5 minutes for questions. So I am going to unmute Sarah and Anna. You guys want to just ask maybe just a few of the questions that people have?
Yes, Val. There's a question on the look back period as to how it will apply to those who are transitioning from mainstream to HRA when they turn 65 or get Medicare.
It's a great question. It's one of the questions we're asking in our comments, because, and we're urging them not to apply the look back to them. I mean, they're saying the look back won't apply to people on Magi. So now that they're converting to non-Magi, in fact, in our comments, we gave an example of something that would be so unfair, but by my colleague Peter Trevisky. So, like, let's say you have a grandparent who was a caretaker relative for his grandson, and he was on Magi, and he paid for some of the grandson's college. And now the grandson's aging out, so he can't, the grandfather is no longer a caretaker relative, and he's out of Magi. And now, will the grandfather now have to do a look back and use that transfer, even though it was exempt when he made it? So that's a great question. And it's, I urge whoever made that question to send comments to the state about that. They haven't actually published regulations yet, but they just sent in a proposal to amend the waiver authorizing MLTC. So I think that there will be more opportunities to comment, and their comments due next week. But it's a very good question, and we don't know.
I'll turn it over to Sarah for the next one.
Okay.
Okay. Well, we got like 8 or 9 questions in the home care section from Trina. I'm wondering if I should just unmute her and you could pick one that you want to ask. I'll see if she wants to do that. Okay, she's unmuted.
Okay.
Pick one of hers.
Yeah, I mean, we really literally have 3 minutes, because my husband teaches a course and he gets the computer in 3 minutes.
Yeah.
So
I'll email.
question.
Can you hear me?
Yes?
Yeah.
I'll email Valerie later. Go to someone.
Okay. All right.
Okay, then one other quick question is this going to be posted on NY Health Access?
It will be. It will probably take a week or so, because it happens I'm going on vacation tomorrow. So you can check back like the week after next, and it will be posted.
Okay, and then we got 2 questions about where notices are sent for disenrollment from a nursing home. Are they sent to the home or the nursing home?
Well, the state, we asked that many times in advocacy that we did with the Legal Aid Society, and they would only say whatever address New York Medicaid Choice had on record, which would probably have been the consumer's address in the nursing home. They never answered that question. And we asked for the notices to be sent to designated representatives of the consumers that are known to the nursing homes, and they never asked the nursing homes for those lists. So this is, going forward, it's advocacy, more advocacy needed to really demand that those notices go to family and go to the consumer's home. It's a very good point. We asked for them to send a duplicate to the consumer's home where somebody might be checking mail, and they would not say whether they did or didn't, but I assume they didn't because I haven't heard of anyone who got it at home. All right, one more.
Okay, Anna, do you have any? Because those are mine.
Yes, on the look back, somebody asked when they need to report now the spouse's income, do they consider a spouse somebody who is not living with them or is separated from them, but still legally their spouse?
That's a great question. I don't happen to know the answer to that offhand. I don't want to risk being wrong. So I'm not sure.
Okay.
Okay.
Great, that's it.
Okay. Well, thank you, everyone. We will be posting this in a week or so online, and you will get a notice of that. So thank you for participating, and take care and stay well.
Thank you.
Thank you.
Thanks, Val.